Good morning. I'd like to welcome everyone here. Thank you for joining us for the program. My name is Doug Verge. I am the co-chair of Sheehan Finney's Data Privacy and Practice Group. My colleague JP Harris is the other co-chair. JP deals primarily with data breaches and litigation, also document retention and litigation and document retention and destruction programs. I deal primarily with the data privacy compliance and regulatory aspects, and that's essentially what we're going to be talking about today. So a few housekeeping things. There will be a Q&A at the end. You can submit your questions in writing and I will respond to them. And I also wanted to let you know that I've done a 12-week blog series, or am doing it, it's underway. And you can access that at our website, www.sheehan.com, under resources. We will also send you a link to the presentation and to the blog at the end of the presentation. There's a few housekeeping things I'd like to talk about from a presentation point of view in terms of terminology and the like that we'll be using today. So the first thing is, what is personal information? So personal information is essentially any information that identifies an individual, and we're going to be talking about data subjects, sort of interchangeable with individuals, but a data subject under the privacy laws is an individual whose personal information we're discussing. So again, personal information is anything that identifies or it could identify a data subject. And once you have a data subject who is identified or can be identified, it also includes any information that is not publicly available about that individual. Now, publicly available is not quite as clear-cut as it might seem, because there are some privacy laws that say, even if my name and my address and phone number exist in some publicly available registries or documents, if I obtain that from you or from some other source that isn't a public source, contract or what have you, then it's still considered personal information under the personal information laws. Other terms that I'll be using today are controller. The controller is the person, individual, or entity that decides what personal information to collect and why, and the general means that will be used to process the personal information. I'll define that word process in a minute. And a processor is the person or entity that processes the personal information for the controller. California uses different terminology. It instead of controller, it talks about businesses. And instead of processors, it calls them service providers. California also has added some other categories like contractor and third party. The word process is very, very broadly defined in the privacy laws, and it essentially means anything you could do with personal information. And that means even potentially have access to it, even if you don't access it. But it would include obtaining it, sharing it, disclosing it in some fashion, maintaining it, destroying it. So anything that you could do really with personal information. So when you think about processing, you have to keep a very broad perspective of that. The other thing that I will say just generally, because I'm not really talking specifically in this more general program about whether what the differences might be between an internal and external privacy notice or policy. And I'm going to use the word privacy notice. You'll often see the term privacy policy, and I believe that's what California calls them. Most of my colleagues would agree that policy is something that's internal. It's the way you internally have decided to handle things and how you want your employees to do it as well. A notice, or sometimes called a privacy statement, is something that is presented to the outside world or to your employees, that are not your internal methods for doing something, but to let people know what your practices are. So You can call them pretty much anything you want, but I prefer to use privacy notices. And I always recommend to my clients that they consider having an external privacy notice and an internal privacy notice. And the main reason really is there are a number of things that might apply to your employees that don't apply to outside persons, and vice versa. So for example, you might have a number of limitations on employee privacy that relate to monitoring of their activities or their locations and the like. There are a lot of, obviously, many HR employment considerations that apply to individual employees that would not apply to a website visitor. So when I talk about the various general concepts related to privacy notices, please keep in mind that it's always a good idea to consider having two separate types of notices. Okay, so what is a privacy notice? In most general terms, it is a notice which is usually in writing, although not necessarily, that you provide to data subjects that describes your organization's privacy practices. It's not limited to online activities. It actually applies to collection of all personal information, even in person. So you may have been on the phone with somebody and they're about to get your name, address, phone number, maybe some other information. They will read something to you often that lets you know what they're collecting and what they're going to do with it. So if you look at the bottom of this slide, there's something called a just-in-time notice. And that's a concept I think that California tends to use. But under California law, you have to notify people at or before the point you're collecting information. And then there's also a separate aspect of California law which deals with privacy policies and the like. So the important thing is, before you do anything, collect any personal information, including if you're collecting personal information from third-party sources, you need to let people know ahead of time what you're going to be doing with that information. So you can post it on a website. It should be on mobile apps. You can have it at a reception desk, anywhere in your office where people can get it ahead of time. So this is a question that people ask me all the time. Does my organization need a privacy notice? The answer is not necessarily, but it's a great practice even if you don't need one. And we're going to talk about why in a minute. But there are federal laws. The US is one of the few countries, I think surprisingly, but maybe not, that doesn't have a comprehensive federal privacy law, a general privacy law. Most other major countries have one. Some of the key ones are the General Data Protection Regulation, which is known as the GDPR. That's in Europe. The UK now, with Brexit and having separated from the European Union, has the UK Data Protection Law of 2018. China just enacted a very comprehensive law. I think it's the PIPL. I forget exactly what it stands for. Canada has PIPEDA, and Switzerland has one, and Brazil has a very robust one, and many countries. So anywhere you're collecting personal information or you're going to do business, it's advisable to check what the laws might be that apply there. As far as federal laws, there are many industry-specific federal privacy laws, FERPA for education, HIPAA for medical healthcare information. You have Gramm-Leach-Bliley that applies to financial institutions like banks and lending institutions. And then there's the Children's Online Privacy Protection Act, which is also known as COPPA. And that applies under certain circumstances where you're collecting personal information of minors defined to be children under the age of 13. California has a law that relates to minors, and they're interested in children all the way up to age 16, but they have variants of what you need to do in terms of opt-in, opt-out notice, depending on whether they're over 13 but under 16. So state laws, there are a number of US state laws that have enacted privacy laws, general privacy laws, California being the first with a very, very substantial amendment, the CPRA. So California law is called the CCPA, and they amended it effective at the first of the year, but it's not being enforced, thankfully, for most of my clients until July 1st. And so there's still time to put in place what is necessary to comply. Now, a lot of clients don't fall within the coverage of the state laws simply from a standing point of view because they don't collect enough personal information from residents of those states, or in the case of California, they don't have enough revenue. California has a threshold of $25 million of annual revenue from all sources and all locations. So it's your overall revenue. Or presently, it collects the personal information of at least 50,000 residents of the state. I believe that went up to 100,000. Most of the other state laws have that 100,000 threshold, but you have to look at each, law specifically. Some of the other state laws that have these comprehensive laws are Connecticut, Utah, Virginia. There's a couple of other ones. And Nevada has a somewhat limited, I call it a quasi-comprehensive privacy law because it has some limitations. But if you're, again, collecting any personal information from residents of states other than your own state, or you're doing business in those states, you need to be aware of what those laws are. When foreign laws, I say, who wants a cookie? But I'm sure everybody has heard about cookies, and probably you're pretty tired of seeing those cookies notices. What that relates to primarily and why you see it has to do with the GDPR in Europe. But it's not just the GDPR. There's another law. It's called the E-Privacy Directive, and it only becomes a law if a country in Europe makes it a law, adopts it, but most of them have. And so that says that if you either implant a type of technology on someone's device, browser, or you use a technology to extract information from someone's device or browser, it's not necessarily personal information, then you have to notify them that you're doing this. And so it's a cookie is a little piece of code that can track people, follow them around. But there are other devices like a web beacon that you don't actually implant on somebody's device, but if somebody downloads a document or they open an email, the web beacon could be there. There are many other types of technologies that you have to be aware of. So when you see a cookies notice and it talks just about cookies, that's really not adequate, because if you're using web beacons or pixel tags or embedded scripts or anything like that can track people around, then you have to be cognizant of that. The privacy law is also, like California, it talks a lot about cookies and other technologies, but the actual notice that you see pop up is because of UK law or GDPR law. When I say other, there's a couple of other significant reasons why you'd want a privacy policy. There are the Federal Trade Commission, FTC, is the guardian of unfair and protection against unfair and deceptive acts and practices. And so even if you don't have to have a privacy policy, if you don't disclose to people what you're collecting and what you're doing with it, there are a lot of creative lawyers and some aggressive, privacy advocates who will potentially want to bring some kind of action, because they weren't informed about what you collect and what you do with it. The other thing, and this is really important, and it's funny because the other day my wife was trying to describe to some of her friends what I do, and she said, well, those long and boring notices and terms of condition and the like that you see on websites or when you go to download some software. She said, well, that's what my husband writes. And the operative part there is, she added, that you never read. And that's a big problem, because am concerned that many times my clients don't read the things that they're agreeing to. And I'll give you one example, Google Analytics. If there's language in the Google Analytics general terms of service that require you to have a privacy policy that covers certain things, and also requires you to include some specific language about Google's privacy practices with a link to where website visitors can find out about those practices. And you have to really look carefully at all of your service agreements for those types of requirements. So some other reasons, even if not required by law, that you should have a privacy notice, to me, one of the most obvious is trust and confidence. All things being equal, if I'm considering visiting a website or doing business with a company, and I see somebody, like Google or, Amazon or a company that has extremely detailed and robust privacy and security practices, I'm probably going to work with that company, as opposed to some small data center that has very little in the way of privacy protection. One thing I want to mention too in that regard is a horrible idea to, I'll put this in quotes, borrow someone else's privacy notice. I see clients who do that all the time, and I'll say, where did you get that? And we saw this really good one that it's the same industry that we're in, and we just used that one. Well, I remember when I was a new lawyer and I had never done a business sale. And so I borrowed a form from one of the senior partners here. And at one point during the negotiations, the lawyer on the other side said, why do you have this clause in here? That's not even part of this deal. And I had made the bad assumption that my very excellent partner wouldn't have put it in there if it wasn't necessary. But you absolutely have to go through your own practices and make sure that everything in your privacy notice is what you do. And one of the worst things you can do is say that you do something or collect something or give a right that you don't give. We talked about consumer protection. You can also be sued under the common law for negligence or unfair or deceptive acts and practices. And the other thing to keep in mind is that things change. So there are new laws being propounded all the time, but the other thing is your practices might change. So for example, you might never have monitored people's behavior through cookies or web beacons, and all of a sudden you decide you're growing, you want to hire a digital marketing firm and or Google Analytics so that you can figure out how people are using your website and what they're clicking on, what they want to buy, what they're interested in. You are responsible for all of the collection practices of the service provider like Google that's acting on your behalf. And you have to disclose what they're doing on your behalf. You can't just pass the buck over to Google, although you can reference Google's privacy practices, as I just mentioned, you might be required to by Google, but you're responsible. And so once they start collecting things like IP addresses, which is a type of personal information, it's a technical identifier, then you're now pulled within certain laws where you might not have been before. So the key elements of a privacy notice, the first and most important thing is you're informing data subjects about your organization's privacy practices. So think of it, I think of expositive writing from when I was a kid, the who, what, why, when, where, and how of something. That's really what your privacy notice is. So you're telling people what you collect and why, what source you're getting the personal information from. Could be the individual directly, could be from a third-party source. You might even be buying it from someone. Do you sell or share the personal information? If so, with whom and why? Now, selling is an interesting concept because you and I probably think sell means, well, here's my list of personal information and you give me money. But California, for example, says that selling is much broader than that. And in fact, sharing or allowing someone to use the personal information for their own purposes could be considered a sale. So when you hire a digital marketing firm or you use an analytics firm like Google, again, you have to read very carefully what the terms are, because usually they'll say that they can also use the personal information or share it with other people, for example, a digital marketer within their network. And under the law, California comes to mind in particular, that if you are selling, you have certain notices. You may see "do not sell my personal information" notices on people's websites. That really comes from the CCPA in California. And then you may be opening up yourself to liability if you're the processor and or the controller, if you haven't limited what the processor can do. And we'll talk about that in the data processing agreement segment too. The other thing that you have to explain is how long you keep the personal information. And if you can't give specifics, then you at least need to give criteria for how long you keep it. For instance, generally between 3 to 6 years, or is otherwise required by our document retention plan. So the other key thing that a privacy notice does is it lets data subjects know what their rights are. So some of them are obtaining a copy or access to their personal information. They can object to you processing it. They can ask that you limit or restrict it. They can ask it be deleted. Another one that I probably should have put in here is the right to rectify or correct the personal information. That's a very important one. It discusses how personal information is protected, and it would include state and country specific provisions or addenda as needed. So if you fall within the UK, you put in an addendum, or you can build it into your policy to cover that. Next, we're going to talk about data processing agreements or addenda. And the reason I put in addendum is because usually you have a data processing agreement when you also have a master services or some type of services agreement in place. So you might have a data center that's storing your information. You might have an analytics company like Google Analytics that's analyzing your information. So it's people who are processing personal information on your behalf and that are outside your organization. I use the term addendum because it usually is just an addendum for that, but you might not have a master services agreement in place, but you still need to control under various laws what a processor is doing with personal information. There are very specific requirements, for example, under the GDPR as to what you need to have in a data processing agreement. In California, it's a little simpler. The main thing is you have to limit what the processor can do with the personal information to using it only for the purposes of performing the service for you and your instruction. And there are some exceptions under California law that would allow a processor or service provider, as California calls them, to use personal information as otherwise allowed under the statute. It's really designed, this type of agreement is designed to protect the personal information that other people are processing, as I say here, to keep them in line. But make sure they follow required laws, that they limit the use, that they have certain reporting obligations to you. They have obligations to cooperate. If there is an audit by a data protection authority, they're going to cooperate. If a data subject makes a request, even though they're not responding to the request, that's your responsibility, they have to cooperate. You may want to consider trying to put in indemnification provisions and other things like that. So even if you are not required by law to have a data processing agreement or addendum, it is really important that you have that. And I call these, again, the big three. The topics we're talking about today are the things that are most likely to give rise to liability, either an action, fine by one of the data protection authorities, or a suit by an individual, even class actions. I'm seeing a lot of class actions nowadays because some of the newer laws are allowing private rights of action against companies. And you have to keep in mind too that, for example, under the GDPR, fines can be up to 20 million euros or more. And in the US, for example, under the CCPA, it's more of a per violation type of fine. But the issue becomes, well, what's a violation, a separate violation, and that can turn into a pretty big amount of money if a lot of continuing violations are occurring. So California, for example, California is really kind of unusual in the way it's gone about this. It doesn't use the same terminology as virtually any of the other countries. It's come up with these other concepts. Instead of just having a controller and a processor, it has a business, a service provider, and now under the new CPRA amendments, there are contractors who are people who receive personal information, but they don't necessarily process it. So an example would be a cleaning service or somebody else that might need to know, if a cleaning service comes in, they might need to know my name and all of my colleagues' names, so they know what room to clean, or there could be other examples I'm sure you can think of. But and then they have a category in California called third parties, which are people who aren't contractors and who are not processors or service providers. It could be somebody that you sell the personal information to or license it to. And then a really important thing with data processing agreements is personal information transfers from foreign countries to the US. And we'll take Europe in particular. In order to transfer personal information of persons located in the European Union to the US, and I say located because it's not citizens or residents of the European Union. It could be US citizens who are there for a temporary assignment or what have you. But if people are located in the EU at the time the personal information is collected, then it has to meet certain legal bases in order to transfer that personal information out of Europe to the United States or other countries. And so the most important one is called an adequacy decision. And what that means is the European authorities have assessed the privacy laws and regime and practices of the other country and determined that its practices and laws that protect personal information of individuals are reasonably equivalent to the laws in the European Union. Well, we had something called the safe harbor between the EU and the US a number of years ago, and a fellow named Max Schrems, who was a privacy advocate, and I think he always seems to bring these cases against Facebook as the example case, was able to get the highest court in the European Union to strike down that adequacy decision, mainly because of surveillance and other practices that the US government could be undertaking without proper protections in the court's point of view to people located in the EU. So then, after a period of time, the EU and the US entered into another adequacy decision called the Privacy Shield. Max Schrems comes along in Schrems 2. He manages to get the court to strike it down again, also because there were not sufficient protections, particularly from surveillance and the like by the US government. So now it's underway that Europe and the US are working on some new adequacy decision, and I'm sure he'll go after that one too in due course, but at least it will give some relief in the meantime. But if you don't, you had to self-certify in the US to be part of this adequacy decision. And if you didn't do that, and it is rather, time-consuming process, and often it was only the bigger companies that were doing it. For everybody else, we were using things called the standard contractual clauses, which are a set of contractual terms that you had to adopt verbatim, and that would satisfy in place of an adequacy decision. The problem was in the second Schrems case, the court said, well, people can't by a private contract bind the government and prevent the government from its surveillance activities. So there needs to be something more. So the European Union Data Protection Board came up with about a 40-page document that explained all the different ways you might be able to add to something more. From my point of view, the only one that may be viable to really truly protect would be encryption. And that means encryption when you're transferring the information, encryption when it's at rest. But here's the sticking point. I know IBM has a really expensive program that can encrypt while the data is in use. but virtually no one encrypts the data when it's in use. So if it could be sitting there encrypted in a folder, but as soon as you open up the folder to look at it, it's not encrypted anymore. So in theory, the government could intercept it. They could have a spy in your organization looking at your screen, taking pictures. And these are the kinds of things that the European government's concerned about. So we've had to do things called transfer impact assessments to try to give reasons why it's still safe to transfer data to the US. Again, does my organization need one? Well, there's not a federal law per se, like the GDPR, that requires this. It may be necessary under certain industry-specific laws. State laws, again, like California and some of the other ones, have some provisions that deal with having processors processing, and foreign laws we've talked about. From the other point of view, again, it's just a good practice to avoid potential lawsuits by privacy advocates or probes by the various data protection authorities. So I highly recommend that anytime someone is processing personal information, you have a very robust contract that lays out all of their obligations and responsibilities and limitations. And also we talk about trust and confidence again, but that any of these data privacy protection mechanisms that we're talking about, you always have to consider that trust and confidence of individuals who deal with you is critical. The consumer protection and common law liabilities are somewhat similar. If adequate protection wasn't undertaken, then you're opening yourself up to lawsuits anyway. And the whole things change again, that applies pretty much equally here. So the key elements of a data processing agreement, first and foremost, it identifies what personal information will be processed and what the purpose is for the processing. Then it sets out legal and contractual requirements, including limitations on the processing. So the key limitation is you can only process personal information for the reasons that I'm telling you, and they have to do with my business purposes. And again, there could be exceptions in the law. If let's say European law applied, there might be some, let's say that you have a right to archive some of the personal information. And so maybe there would be exceptions based or built in for legal exceptions. And it allocates responsibilities and liabilities. I talked about this a little bit before, but who's responsible for responding to data subject requests? Who's responsible for responding in case there's a breach? And that's one of the critical things, is that you want to make sure that if the processor is suffered a breach, that they have to notify you of that. And something that relates back to the why you would even have a privacy policy and these other requirements in place, is that while not every state, in fact, only very few states right now have comprehensive data privacy protection laws, I believe every state has a data breach law and a data breach notification law. So you may have an obligation under state laws where the data that apply to the data breach that would require certain notice. So if it was your processor's data that was involved in a breach, you would want them to tell you immediately, and then determine what, if anything, you have to tell your data subjects about, and the authorities. Maybe you need to notify the Attorney General, or in some cases, you might have to publish a notice. The other thing that the data processing agreement does is it addresses the use of sub-processors. So a sub-processor is a processor hired by a sub-processor. So let's say that I have a payment processor that's, I have a shopping cart, and I have a payment processor that's I have a direct agreement with. That payment processor uses a data center to house all of the personal information for all of its clients. That data center is a sub-processor. I don't have a direct relationship with the sub-processor. but I'm still responsible for the processors processing of the information if they're acting on my behalf through the processor. I know it's a little cumbersome, but that's the way these data privacy laws work. So you would have to make sure in your data privacy agreement that you're having your processor enter into an appropriate agreement with any sub-processors that it uses. You also would usually want a list of who they are, and you would want to be able to approve or not approve of them and the like. These agreements also address security. What you want to know what measures are being undertaken to protect the data. They address cooperation, as I said. They also would allow for audits of activities. You want to be able to go in and make sure that the processor is doing what it says it's doing and what it's supposed to do. And we talked about the CCPA and limiting the processor's activities for your purposes. The last area, and in some ways, maybe even the most important one, and regardless of any laws that apply, everyone should have a written information security program, also known affectionately as a WISP. What is that? It is a written summary of your organization's technical, physical, and administrative, or some people say organizational security measures. So it basically puts in writing what the measures you have in place, how they're implemented, and who within your organization is responsible for those measures. Do you need one? Well, well, I should say, I would dare say that all of the applicable federal laws have security requirements that would talk about, even in a most general sense, certain security measures that you have to have in place. All of the comprehensive state privacy laws would also talk about security, even though they might not always get into great detail. The foreign laws, like the GDPR, go into much more detail about what you need to cover and have in place with your written information security program. And again, the Federal Trade Commission, I will tell you that most of the actions I've seen by the Federal Trade Commission have involved breach of security and hacking or not taking proper measures, things like that. So probably the single greatest thing you can do to protect data is make sure you've got a proper written information security program in place. And we'll talk about what's involved in that in just a minute. So it's the same. I know you're probably tired of seeing the same old here, but it's the same thing. In every case, having proper security and letting people know what that entails is going to build trust and confidence in people who work with you. The consumer protection aspect is huge. And in fact, when I think about some of the largest, multi-million dollar, hundreds of $1 million fines that have been imposed against companies under the GDPR, it almost always has to do with failure to properly protect personal information. And another thing to keep in mind is that under some of these laws, if you've taken proper security measures, and especially encryption and transmission and at rest, you might not have to provide certain notices of data breach, or you might be protected from liability. So it's important to know what kind of things you need to be implementing in order to take advantage of those protections. And again, things could change. You've hired someone else, or a new law has passed, or you've hit a certain level of collection of information. Now you're up at that 100,000 or 50,000 person level, or you've taken on a new aspect of your business where you're selling personal information, and the volume of personal information you're selling has or sharing has pulled you within a particular law. So you have to do a constant review, at least on an annual basis, but earlier if your privacy practices or the operations of your business change materially. What are the key elements of a WISP? Well, the first thing is you identify risks. And some laws actually require risk assessments, but it's always a good idea. It should be a best practice of your organization before it's going to collect any kind of personal information to identify the risk. Well, the general risk is always that some unauthorized person is going to get a hold of it, right? But there could be specific risks that are particular to your operations. And I think in my template, WISP template, probably have 10 or 15 different specific risks that could apply, and they don't apply necessarily across the board to everyone. They set forth technical security measures that you're going to undertake. So one example, or some examples from a technical point of view, would be firewalls, access controls, anti-malware software, penetration testing, having somebody from the outside even come in and see if they can break into your system. Then there are physical security measures. Examples are, obvious things like locks on doors and windows, surveillance cameras, having a receptionist. I've done, receptionist login badge and escort policies for clients to make sure that they've satisfied the physical measure aspect. And then the administrative or organizational security measures really have to do more with your internal policies and procedures. So in addition to having the WISP in place, you'd want various security policies that you share with your personnel. You absolutely need to have an emergency / disaster / business continuity plan. If there's some horrible thing like an earthquake or a war, something happens, how are you going to get your business back up and running, and how long is it going to take? And people who deal with you want to know those facts. You have to have a data incident and breach plan, and JP does those for clients. Document retention and destruction policy and plan, also something that JP works on. You need to train people. You have to have training procedures in place. That's part of your plan. How do you go about training, and how often, and what kind of training do you implement? And then you have to have day-to-day record keeping policies and procedures, because all of these privacy laws require you to keep records of what personal information you're collecting, what you're doing with it, how you're disposing of it. I have different forms of, I call it data mapping materials, to help clients figure out all of those things. What are we collecting? How long do we keep it? Who do we share it with? I have a very robust form that's a very extensive Excel spreadsheet that would probably take a lot of people power and time to complete. I've implemented more recently some checklists that kind of lay out the typical reasons that you collect, who you would typically collect from by category, and it just sort of simplifies things. It's not ideal, but I find a lot of clients just don't have the time or the resources. So it's more important to be as comprehensive as you can, even if you can't get into the bug dust, as one of my partners used to call it. The other thing a WISP does, it assigns responsibility. So who in your company, is it a chief information security officer? Is it the head of IT who wears a single hat for everything? Who else, our department has responsible? So it kind of sets up a flow chart of who's going to take care of what and in what order. And there are many, many internal policies, programs, plans. I think the last time I checked, we had a list of, and I worked with the head of our IT security. I think we came up with a list of maybe 20 or 25 different possible internal policies, programs, and plans that you could have depending on your circumstances and size of your company and what have you. The other thing is that a very good written information security program is going to map itself to recognized standards. So ISO 27001, NIST 800-53, there's the NIST cybersecurity framework, and then there's the CIS. I've seen it top 20 security controls, and then I saw 18. I don't know why 2 would go away, but anyway, when Kamala Harris was the AG in California, somebody said, well, how do I know what to put in my WISP? And she said, you know, look at the Massachusetts law, the regulation about what goes in a WISP, and then supplement it with the CIS top 20. And that's kind of the approach that I've taken. And then I know that you know, our IT person has thrown in a few of the ISO and NIST aspects as well. So the last thing I want to talk about is the Massachusetts WISP law. I mean, you may or may not know this, but if you collect certain types of a Massachusetts residents' personal information, you have to have a written information security program in place. And the law tells you what you need to have at a minimum in that program. So it's required if you obtain a Massachusetts resident's first name and last name, or first initial and last name in combination with any one or more of the following data elements that relate to that resident. So if you have the name and the social security number, or the name and the driver's license or some other state issued ID, or you've got a financial account or credit card, debit card number, even if it doesn't have a required access or security code that would permit access to somebody's financial account, at least potentially. However, it does not include information that's lawfully obtained from publicly available information or from certain government records that are made available generally to the public. So this is a little different than the concept I mentioned about what is personal information. This is just saying, and for this particular statute and purpose, it wouldn't include that information if you obtained it from another source. And the ramifications of non-compliance, they could be vast. And I'm not trying to scare people, but I'm just being realistic. I'm starting to see fines under the GDPR, for example, against, you know, restaurants, smaller companies, even some small dental or medical practices, if you fall within the GDPR, obviously. One of the first things, and now the European authorities are using fines as kind of the first line of approach to get people to comply. They're not often huge. I've seen some $200 or $300, $400 million fines against companies like Marriott and British Airways and Google. Criminal, and I will say there too that, you know, the initial fines were against the bigger companies because they're the obvious targets, but they're starting to go down the line now. So people who could fly under the radar before, that's not so likely anymore. There can be criminal liability, you know, possibly jail time, but certainly criminal fines. There's civil liability, and it can be lawsuits under some circumstances by individuals, even class actions. There's a law called the Biometric, I think it's the Biometric Information Privacy Act or something like that in Illinois. Other states have them, but there have been so many suits brought in class actions under that law where employers or others have collected, you know, facial identification prints or fingerprints or iris prints or scans without taking all the proper precautions. So biometric information is a big thing right now, and geolocation information too. And the other thing that could happen is you could be prevented from conducting business in the jurisdiction that's involved, you know, because you have violated the laws. So all important considerations. And then questions. So I'm looking to see if there are any questions in the Q&A. And I don't see any. So if anybody has a question, we've got about 9 minutes or so. Happy to answer them if you want to type them in the Q&A. All right. Well, it looks like there aren't any. But feel free to reach out to me after the program if you think of something, and I'd be happy to respond to that. And thank you very much for attending. Oh, wait, I see a question. Oh, okay. You're welcome. It said thank you for your time. I'm happy to do it.